Bernicia is going to be giving us a very good talk tonight. We've been very, very lucky to get Michael up here. He's sort of royalty in the 3 months, so let's look at Michael anyway. Let me get started. Notepads and pens and pennies, with a lot of information coming fast.
Just let me know if you can't hear what I'm saying and I'll try and speak up. So, first things first, how many of you in the room have seen me speak before? Okay, how many people in the room are not familiar with freetheplanet.net? Okay, that's my website for those of you who don't know. How many people in the room are not familiar with the remedies that I have obtained with the taxman and the registrar? How many are not familiar? Okay, right. Thank you very much. Now I can just about gauge where to start. So those of you who already know some of this information, please bear with me, because there are some people in the room who are actually there at the very beginning. Where this really began for me was myself and Amit Zala, along with a guy called Tom. We'd all declared that we were no longer going to be governed by Her Majesty's government, and we declared our own sovereignty. And we really took a leap of faith. It was something that we all believed was the right thing to do, and we did it in our own unique ways. And at that time, there was very little information to be gleaned within the United Kingdom, or related, shall I say, to the United Kingdom and Great Britain, and what exactly constituted a freeman and what constituted lawful excuse, and all of the rest of a myriad of terms that were being bandied about by the Canadian freeman movement, which obviously had inspired us to have a look at the law in this jurisdiction to see whether or not we could find remedies for the problems that we were facing every day and the people around us were facing every day, because through our own research, we discovered that there was really no such thing as a bank loan or a credit card loan or a mortgage. That all of the evidence suggested that the banks weren't lending any money, but they were acting as if they lent you money and then charging the principal plus interest. Now, at the time, we were just nutters in the corner rambling on about stuff that people weren't really interested in because they thought it couldn't be true. But so we convened a meeting of like-minded souls who all gathered in Derby, and we put together our information, and we found that there was an awful lot more work needed to be done. But one thing was certain: things could not carry on the way they were. And at that time, there was no information out there in this country for anybody who was interested in any aspect of so-called commercial redemption or so-called freemanism, for the want of a better term. And we decided that at the very least, through our own experiences and our own research, we would just put all the information that we believed was valid out there, and whoever was attracted to it would take it and do with it what they wanted to do with it. And if what we were doing was wrong in any way, we would find out why it was wrong, and if it was right, we'd find out why and how it worked. So we got to a point where we realized that within the system there's very little remedy available, and there's very little protection available from the courts and from the police and from the government agencies. And the corporations who seek to take everything from us in every way they can, every single day that we walk around in this jurisdiction, and not only are wages and salaries either freezing or being cut, but fuel is going up on an almost daily basis, and it's been like this for a long time, as with the price of food and everything else that we perceive as our basic necessities. So, what's the solution? When you go into the system, when you stand up in the court and you say, I demand justice because this prosecution against me would seem to be in breach of the constitutional law of the United Kingdom. What do you do when you stand up and say that and the judge says, not today, sir. Not in my court. Because this has happened again and again and again when people like us have stood up and said no more fraud, no more deception. If this is the law, the court should apply it. But if you're involved in any issue where there is a crown interest or a bank or a multinational involved, and that's virtually every single issue that ever ends up in court, you lose. You lose. So, at the time when we began on this journey, there was a false perception among researchers in our fields that went something along the lines of, stay away from statutes at all costs, you'll just get into trouble. When actually the opposite was the case. The only way we can obtain any remedy from that system is when we do apply their rules and their statutes against them. Now, as I say, most of the time they just rule against you. But we've gotten to a point, after almost 4 years of constant research and constant striving to achieve and obtain remedies that we could share with everybody, that everybody could apply in their own lives. We've reached a position where not only are the judicial system and the legal professions starting to take notice of the allegations we've been making against the banks, we've also been advised by the Financial Services Authority to go directly to the Ministry of Justice and ask the Ministry of Justice to convene a test case in the High Court to decide whether or not the following allegations are true. Every bank in this country who engages in the mortgage business, every single bank that we are aware of is guilty of, as a matter of corporate policy, breaching the following laws. The Law of Property Miscellaneous Provisions Act, 1989, Section 2. In basic terms, that law prescribes that every single mortgage has to have a mortgage contract that all the terms are expressed within before execution and contained in a single document where contracts are not exchanged, and that document must be signed by both parties, the mortgagee, the bank, and the mortgagor, the alleged borrower. If those things are not true about a mortgage or an alleged mortgage contract, there is no mortgage. The contract is void ab initio. That means from the beginning. There is no enforceable contract, which means there is no enforceable debt. That is true of every single mortgage, I repeat, that does not have a Section 2 compliant contract with the signatures of both parties and all of the terms and conditions contained therein. No mortgage is enforceable. And yet, since we brought these allegations to the courts, probably for the first time in 2009, until now, they've been dismissed as totally without merit in English law. They've imposed civil restraint orders against many of us who brought these allegations, saying that if you bring these allegations again in any court, then literally we will arrest you for contempt of court because there's a civil restraint order in place preventing you from doing that. I had that threat myself in the case that I was involved with. And I just want to tell the story of that case, because that case provides the background to the next phase of the development of the case against the Banksters. Okay, so on February the 19th, 2010, I went as representative of my family's private property trust to its bank, and I presented the bank with a promissory note made payable to bearer to the value of the debt that the bank was claiming the trust owed. The trust had, in good faith that the bank had lent them money, mortgaged its properties, or at least they thought they'd mortgaged their properties, but there was never any valid and enforceable contract that was issued by the bank. But of course, at the time, the trust didn't know this. So, in good faith, they presented the promissory note made payable to bearer, which, as confirmed by Lord Denning in the Court of Appeal in 1969, I believe it was a promissory note or a bill of exchange made payable to bearer is exactly the same as cash. In the HBOS Group Reorganisation Act 2006, in the schedule you will find definitions of the terms contained within this Act. And this Act prescribes, among many, many other things, that instruments such as promissory notes, whether made payable to bearer or otherwise, and other forms of negotiable securities are accepted upon deposit by the bank, whether to create lines of credit or to extinguish liabilities. It's there in the Act which covered which covered the legality of the bank in question's actions. And the bank said they'd never ever heard of this kind of transaction before. That a bank who has an international presence, who has been a bank on these shores for 300 years, who was a national bank, did not know about promissory notes made payable to bearer, and the fact that that bank accepts them on deposit and to satisfy liabilities. Well, we said that that constituted prima facie evidence that they were lying. So we sent a whole list of questions to them. We asked for, the notice was a notice requesting adequate assurance of due performance. In this notice we demanded to be presented with evidence that there was an enforceable contract signed by both parties in existence. We wanted evidence of the actual instrument of deposit which created the alleged loan. We wanted them to answer all kinds of questions with regard to the negotiable instrument that we presented, because, as per the terms of the Bills of Exchange Act 1882, Section 43 prescribes that if you tender a negotiable instrument such as a promissory note to someone who claims a debt from you, and if they refuse that debt and you enter into a lawful process as per the terms laid out in that Act, the Bills of Exchange Act, you do a notary protest on it, which we did. If you do all that and the bank still refused to accept the instrument, the debt is discharged. So this is what we notified the bank of. The bank then put in a demand. They ignored everything we said. They refused to answer the questions that we put forward. And so we terminated any existing or previously existing contracts that could be deemed to have been enforced on the basis that the bank had clearly misrepresented the facts. They'd failed in their fiduciary obligation to accept the negotiable instrument in satisfaction of the debt, which meant, in accordance with the laws of banking, as per Paget's law of laws of banking, when the creditor receives the payment for a debt, the remedy to sue for the recovery of the debt is automatically suspended. This is a maxim of commerce. It means that you can't be sued if you genuinely, in good faith, make an attempt to make payment. But what the banks have done is they've shut us all off from this lawful remedy. Every single one of you should be able to go into a bank tomorrow with a promissory note. We can provide you a template for this, and if it has to be a promissory note made payable to bearer, you should be able to go into that bank, instruct that bank to open what's called a private trust deposit account. You make the deposit in that account, it stays there. The credit is transferred into a public side account which you can access. The credit, once it's gone, is not payable back to the bank. The note is what created that credit, and the note, once the credit